Thank you. Thank you for the kind introduction. Dear Mr. President, Dean Liu, thank you very much. It is an honor to speak before you. Some comments to your presentation, because I learned a lot. First, I think the understanding of economics and accounting here in Taiwan seems to be better than in Germany. When our judges try to find a definition of the infringer's profit, they also try to use accounting standards, but they are not going into depth. And when we talk about accounting, just one information. If you want to show IP in the assets of your balance sheet in Germany, it is possible to do so if you bought the assets from someone else. Until about 5 years ago, it was impossible to show IP which was developed by the own company in your assets. So this already makes clear how much difficulties we have in Germany to show the value of IP. Now it is possible to show IP in the assets, which is very important, for example, for biotech companies. They have nothing else. So this is a good idea, and now you go to the tax accountant and the tax authority because you show it in the assets, and then you may want to write it off to deduct your payment if you hopefully have profits. And now the tax authorities ask you, how did you find the value? Okay, I only can ask the question. I have no answer for you because tax authorities also have big problems to give a value to IP. Sometimes we argue in a very primitive way to say that the patent had costs of the patent attorney and of official fees of an amount of so-and-so, and this is the value of IP. This is ridiculous because all the R&D work should be shown. But the tax authorities say, we do not know now whether this development will ever get into a real value. So it's very difficult to show IP in German asset sheets. We also have the DIN 77,100, same accounting standards. It's a good basic ruling, but it does not help too much in day-to-day business. My second comment is you showed statistics about intentional and negligent infringement. And you showed that there is about 40% of negligent infringement. From my experience, there may be even more intentional infringement, but it seems as if people in Taiwan are more honorable than in Germany, because in Germany, no one would say, I do an intentional patent infringement. Everyone is innocent. You may get a judgment against you, but I really wonder how you found this number. So, very good. Let us go to the topic of today. Please let us start with some very basic information. The German patent system is bifurcated. You have the infringement suits, civil courts, which deal about infringement only. They give an injunction, they allow you to get damages. If the infringer attacks validity of the patent, we are in a different system. We are with the patent court, with technical experts as judges, and they will decide about the validity. Infringement judgments are faster. Validity judgments take longer time, and in general, the system in Germany is very much in favor of the patent owner. Our infringement courts are specialized in patent matters. Judges are very competent. They know how to discuss technology. They are no business people, but they have a lot of experience in these cases. And Germany is known for preliminary injunctions. They can be a perfect tool, but preliminary injunctions will not bring any damages. So the system is comparably clear, and when we talk about damages and infringement of a German patent, we have to see what is a German patent and to see what the Patent Act says. First, a German patent can be a national German patent. It can be the German part of a European patent. and you can file a PCT application and design Europe and Germany, whatever you choose as a way to get to a patent in Germany. Our questions here about damages are the same, and the answers are the same. So what does our law say? Any person who performs the act intentionally or negligently shall be obliged to compensate the aggrieved party for the damage caused. Negligence, in German practice, the infringer is always negligent. The argument is the patent is granted, it is published, anyone can take a look at the patent register. As soon as it is published, then you act at least negligent. Of course, in reality, it's almost impossible to check the patent register every day, but that's the assumption of the courts. In other words, it is not necessary to send a warning letter. Even without sending a warning letter, you act in a negligent way to infringe a patent. The European Patent Convention is relevant for all European patents and the national parts of the European patent. And you see here a European patent shall confer on its proprietor the same rights as it would be conferred by a national patent granted in that state. So even for a European patent, the legal basis is German patent law. Now, in general, if a judge examines infringement and damages of a patent, he starts with the examination of the injunctions. He makes his feature analysis of the patent, he compares to the infringement, and then he decides for an injunction. He does not really consider damages too much. Damages just follow the injunction. I would like to show you two scenarios which are not shown in the presentation, but when German judges had difficulties whether an injunction always triggers damages. Case number one is called prepaid telephone card. Just to give you an idea of what we are talking about. You want to do international calls, for example, calls to Germany. You do not want to pay much, and there are some providers which offer lower costs for the international telephone call. So someone invented a system that you buy a telephone card, prepaid telephone card, and then you enter a code and the telephone number in Germany, and this card checks whether you have enough money on your internal account, and if you have enough money, they look for the best price, and then they connect you. This invention was protected by a method patent. Now, there was a company who wanted to offer this in Germany, but the patent was protected in Germany. There have been some countries without patent protection. So the infringer had the following idea. I offer this in Germany, and the server which uses the method, you know how the case goes on, is in a country without patent protection. So the question for the German judges was, is this patent infringement? Question number one is always, which acts of the patent, which features are used in Germany? Answer, 0. The whole process was used in a country without patent protection. And this situation obviously left a bad feeling with the German judges. What should they do? And then they changed their way of thinking, because usually say, we grant an injunction and damage will follow somehow. Now they thought, what happens with damage claims? Because in the country with no patent protection, there is of course no damage claim. What will happen in Germany? The damage is in Germany. So the effect of this activity is in Germany. There is damage in Germany. So they took the other direction to find a solution to this case. And they came to the result, it is patent infringement in Germany, and damage compensation has to be paid in Germany. So this is a little bit a crazy situation for our thinking, because usually we say everything has to happen in Germany, and then it triggers damages in Germany. If this is not the case, then no injunction, no damages. We have here a different solution, and this also shows a little bit how judges in Germany are international in some way, because they try to enforce patent law cross-border. You may know cross-border injunctions have been very famous for some Benelux courts. They granted a patent injunction to cover Benelux, Germany, and some other countries. Under European law, this is not possible anymore. But you see, also judges are inventive. And a case like this prepaid telephone card shows that if they see someone wants to design around a patent, they still try to catch this person. And we have damage compensation in this case of a method patent. Method was used outside of Germany, and the argument of the judges was the trigger to use the method was made in Germany, and the result is in Germany. And if the beginning and the end is in Germany, the infringer makes use of the patent, and it is regarded as if it would be in Germany. So this is one case where you see it's really a little bit strange. Now let's go to a second scenario. Indirect infringement or contributory infringement. We all know these coffee machines with the capsules. Probably you have had a lot of patent infringement cases for this as well in Taiwan. So the patent protects the interaction between the coffee machine and the capsule. I'm the infringer. I only produce the capsule. I make money with the capsule, and you will buy it, and you will start the patented process because you have the coffee machine. So I do not commit direct patent infringement. I only provide the capsule. German law says we want to protect the patent owner, and there is a paragraph 10, and this paragraph 10 in the German Patent Act directs contributory infringement. It is not allowed to provide a component which is intended to be used for a patent infringement. Probably it's the same in Taiwan. Question now, what about damages? Will the indirect infringer have to pay damages? Question 1 for the capsule, question 2 for the use of the whole system. Answer is not clear. The general answer is that the indirect infringer is not liable for damages. I don't like the result, but that's at least the situation in German law. The problem is that German judges say damage compensation has to be paid by the indirect infringer only if the direct infringer exists and it can be proven that there is direct infringement. So in other words, if you want to get compensation from the indirect infringer, we have in some way to file the suit also against the end user, which is not acting commercially. He does not infringe. And then it is very difficult to prove that the end user is also an infringer and has to pay damages. In other words, a lot of indirect infringers get an injunction, perfect, but they do not have to pay damages. In my view, this is a hole in the system. In some cases, also the next user is a commercial user, and then it's easier to get damages from the indirect infringer. But in a lot of cases of indirect or contributory infringement, there is an injunction, but no damage claim. So I wanted just to show that if you have a patent infringement, in general, you have to pay damages. There are situations like this prepaid telephone card where it's a surprise that you have to pay damages because the patent has not been used in Germany, and you have indirect infringement, and the indirect infringer does not have to pay damages as a rule. So what is the methodology of damage calculation? Own lost profit, infringer's profit, license analogy. The same situation you have here in Taiwan. We do not have to say too much about it. And the German system has a certain process to collect information and evidence because in the first suit, we ask the court to give an injunction and to force the infringer to provide evidence. Only on basis of this information we know how to calculate the amount of damages. So the patentee needs the information as to the extent of the infringement, and based on this, the concrete amount of damages can be calculated. It is an action by stages. This means in the stage number 1, we have a suit, and the suit starts with an injunction claim. We define exactly what kind of product is offered. The second motion in this suit is for information. The defendant is ordered to render information to the plaintiff to what extent the acts stipulated in number 1 were committed since a certain date. This is 1 month after the publication of the patent. Just 1 second. So, and number 3 is the motion for declaration of the obligation to pay damages. In other words, this is a statement that the infringer has to pay damages. No concrete amount is given. When this first step is finalized, the patent owner has everything he needs to calculate, and then parties settle, or they have to go to the second step, to another suit, to really get the money. However, most of the cases lead to a settlement. One of the reasons is that the information is something the infringer does not want to give. And the infringer very often is willing to pay even a little bit more just to avoid the disclosure of the information. So statistics in Germany say that about 5% of all patent litigation are settled by the parties. So damage cases are rarely published. There are a lot of settlements. I may want to say something about the timeline and also about unjustified enrichment. Because unjustified enrichment exists also in Germany as a way to compensate. Now I would like to give you a timeline and to show you what kind of damage calculation we have. You are the patent owner, you file for the patent in Taiwan. The patent application is published in Taiwan. I'm the infringer, I don't care. Your patent application is filed also in Germany. The patent application is published in Germany. No grant, only the publication of the application. From this day on, I, as user in Germany, have to pay a compensation. This is what our law says. We are not talking about damages, it's just a compensation, and in practice, this compensation is a license analogy. No patent has been granted, and I only have to pay if the patent will be granted. If no patent will be granted, no such compensation has to be paid. Now let's proceed with the timeline. The publication of this patent in Germany has been done, and it may take some years until you finally have a grant in Germany. From the time of grant in Germany, I am liable for full compensation. Lost own profit, or infringer's profit, or license analogy. I can use all 3 ways. Now, if I use license analogy, there is no real difference whether the patent was granted or whether I go back with my calculation to the publication of the application, because license analogy applies for the whole period of time. So the difference exists only if I feel that I get more money if I ask for the infringer's profit. Then I will use license analogy for the time between publication of the application until grant, and from then I will ask for more, because then I will ask for the infringer's profit. And now we talk about unjustified enrichment. Unjustified enrichment also means you get compensation according to the license analogy. And the important thing about unjust enrichment is that the statute of limitation is longer. You can go back 10 years. If you ask for damages, you can only go back 3 years. So in other words, it happens quite often. You have publication of the application, you ask for a compensation according to license analogy. Then you have a time which is long ago, more than 3 years ago. I do not get damage compensation because it's statute barred. I still ask for compensation according to the license analogy as unjustified enrichment. And now we come to the third stage. Now we are within the 3 years, and now we ask for the full damage compensation according to the infringer's profit, which is a terrible calculation because you need all the documents to provide this, but this is a part of the work of the attorney. So again, most of the cases, about 5% of all patent litigations are settled when it goes to damages. When we talk about infringement, there are much, much more decisions. And we also have to see that our judges are good judges, but it's nice for the judges if they do not have to write a written decision. In other words, leading the parties to a settlement is also good in the interest of the judge because he has less work on the case. Judges are also human beings, at least in Germany. And the other aspect why judges lead the parties to a settlement is they say these parties may meet each other again. And it's always better if the parties have some kind of agreement because there is not so much bad blood when they meet each other again. So finding an agreement may be the better business solution. So when we talk about the infringement suit, at the end of the infringement suit, the judges very often try to push the parties to a settlement, even if damages are not really a part of this first stage. So it goes like this. The judge says, patent owner, you may have a chance, but you have certain risk. I'm not sure whether you can really prove that feature E of the patent claim is infringed. Infringer, you also have a real risk. And you can go on with the litigation for the next 2 instances and you will not know what to do. I propose the following. Infringer, you stop it, you give a cease and desist declaration. You will stop it within 2 months so that you can sell existing products. And now, infringer, how much turnover did you have? And then the attorney very often says, I do not know, or I am not allowed to tell it. And then the judge asks the patent owner, what do you expect? How much does he have? Then the patent owner gives a high number. Then the judge says, well, this may be a little bit too much. I propose a lump sum of X. Maybe 50,000 euro, 100,000 euro. So these are payments for an average or minor patent infringement case. And then both parties ask for a timeout. They leave the courtroom, and then both attorneys call the client. And then the client asks, nice, if we proceed with litigation, how much will your attorney fees be? And this is exactly the amount which also the judges take. The judges calculate the attorney fees for the appeal instance, for the point of appeal instance, and then they are in a figure of 50, 100,000 euro, and then they add something on top of it as damage claim, and then they say, well, both parties, this is a risk, and even if the losing party has to pay the attorney fees of the winning party, but there is a risk. And you see there is a lot of pressure, and then a lot of cases are settled. So this is the reason why there is 5% of the cases only go to the damage calculation.